I've heard the phrase success fatigue. And when I first heard it, I knew exactly what it meant, that you have to keep proving yourself. So what I would say to my sisters-in-law is it is worth it, that continuing effort to show that you can do it, the underestimation sometimes, and that it's worth it because of the satisfaction that we get from helping our clients, making a difference in their lives and making it a difference in society.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share this conversation with Mary Alexander. I'm interested in talking a little bit about your bicycle case, the faulty brake case.
So am I.
Okay, wonderful. By way of background, I have some Yosemite history. So that's
What is that?
Well, I was born there.
Oh.
And my dad worked for the Curry Company back in the day.
Oh, my goodness.
So my dad was born there. My grandmother was a PBX operator for the Iwani. My grandfather was the head bellman. So we've got kind of deep roots. Now, obviously, not a Curry Company affiliation from the time period, I think, where you were handling this. But when I saw Curry Company as the defendant on a brake case for bikes, which is also a passion of mine, that was the one that I wanted to ask some questions about. So can you tell us a little bit about what I know the injury is horrible, but can you tell us a little bit about the case?
Well, picture a young woman coming into Yosemite Park, renting a bicycle from the Curry Company and a coaster brake bike. She rode down the hill from Lower Yosemite Falls. The brakes didn't work, and she crashed into a tree headfirst, breaking her neck, and then was on a breathing machine for life.
That's awful. The Curry Company is a concessionaire, so you don't have to deal with the Federal Tort Claims Act, correct?
Yeah, we did not sue the government. We didn't sue the park rangers, just the Curry Company.
But you are in federal court, probably in Fresno, right?
I think we may have started there, but we were in state court. It was tried in state court.
Well, that's fortunate.
Yes. We were in the state court, and what we set about to do is to show that they had other accidents. And we found that there were people from all over the world. We brought somebody in from Japan, Australia, people who had rented the bicycles and crashed in the very same place. And what the case was about is that the bicycles that were coaster brakes, first of all, they never should have rented coaster brakes to people who were going to be riding on hills, because you can't get enough of braking power with them. And we said they should have rented ones that had handbrakes. We couldn't possibly rent handbrake bikes to the public. And during the course of the case, I went on vacation to Maui, where Haleakala Bob rents handbrake bikes to ride down Haleakala volcano. I got one of his brochures that showed pictures of people from the public riding down the hill with a huge volcano with bicycles with handbrakes. And I got it into evidence with the judge.
Wow.
He allowed me to do it. The Curry Company had a concession, you probably know this, 60-year contract with the government. It ended up during the pendency of the case that contract ended, and a big media company of all things from L.A.
MCA.
bought it. Yes, that's right.
That was when we left the park.
Is that right?
Mm-hmm.
I can't believe you and I have this connection. So, but the case was still against the Curry Company.
Yeah.
We learned during the discovery that the bicycle brakes and a coaster brake, they're actually 4 little pieces that squeeze together to stop the bike. And when they would repair these bikes, they would reach into this box of old used brakes and put them into the bicycle. We were able to prove during the trial that the wear pattern on these 4 little pieces were different, so that they had been used. They weren't brand new when they were put in. They were used. And they would have teenagers working there in the summer to repair these. I hired a guy from my local, I lived in Los Altos at the time, a local bicycle store. Had been repairing bikes for 10 years, and had him come in to tell the jury about how you repair bikes and what was the matter with these brakes. One of the stories from the case is that the defense lawyer would come to depositions and he had a bicycle brake, and he would swing it around and play with it. And a light bulb went off in my head about a story that one of my partners had told me. He had come from Chicago and he had tried a case there where the brakes didn't work in a car. And he had his expert on the stand. And his expert was explaining to the jury what went wrong with this brake. And after the direct exam came time for cross-exam, and the defense lawyer put this table in front of the witness stand and had a white piece of paper on it. And he put an example brake on the table and said to the expert, "Will you come down and show the jury what you mean?" And the expert said, "Well, I don't have any tools." The back of the courtroom door opens and in comes a cart with every tool imaginable. And he said to the expert, "Now will you come down and show the jury what you mean?" The expert hung his head and said, "I don't know how." I don't need to tell you that plaintiff didn't win that case.
Yeah.
But I thought about that war story. And so I got an exemplar brake, sent it to my guy expert from my local bike store that was going to be testifying. And I said, "I want you to be able to take this thing apart in your sleep." He said, "Okay, Mary." So I'm about to put him on the stand the next day. I call him up and I said, You're going to be able to do this, right? Take it apart." And he said, "Yep, I'm ready." So I did my direct, and to my surprise, utter surprise, there was already a table placed in front of the witness stand by the defense with a white piece of paper on it. So after I'm done with the direct, the defense lawyer he was kind of a aw shucks country lawyer kind of guy, and he shuffles over, puts the exemplar brake on the piece of paper on the table, and said, "Would you come down and show the jury what you mean?" And so my guy comes down and he goes, opens it up. I was so proud. Well, it was an example how a war story can help you.
Yeah, well, and we talked a little bit about this in our preparation call. I know that there are some people who are down on what they describe as war stories. And do you have any thoughts about that as far as a learning mechanism for younger lawyers or older lawyers in terms of sharing information?
I think they're great. The story helps keep it in your mind rather than hearing, well, just make sure your expert's prepared. An example of how your expert needs to be prepared. I think war stories are really useful. I love them. And they certainly have educated me and prepared me for cases.
I want to pivot from cases for a moment to talk a little bit about some of the work that you've done in the mentoring and teaching world.
Would it be okay if I tell you another story from the bicycle case?
Please.
Because it's illustrative of, it's a war story that I think could help people.
Yeah.
So the defense hired a really great bicycle expert. And he'd been in the Tour de France. I mean, he knew how to ride bicycles and knew all about them and testified a lot. He put a video camera on the front of his bike, went to the top of the hill, which was Lower Yosemite Falls Hill, and rode down the hill. he had the audio on of his video. He gets to the bottom of the hill where the trail made a sharp right turn. And the problem was that my client couldn't slow the bike down enough to make the turn. And she just went straight headfirst into the tree. He gets to that point, and on the video, he makes the right turn, but he says on the audio, "Oh, I almost lost it."
That's not good for the defense.
Not good for the defense. This is this expert Tour de France guy. He's got the 12 speed hand brakes, and he almost lost it. And he knew all about the case. He knew all about the hill, and he had trouble making that right turn. So the moral of that for your experts is don't have the audio on.
Yeah, definitely. How did you figure that out? I imagine there was a big expert file. There were videotapes. Did you?
He produced it at deposition.
And I'm presuming the defense lawyer must not have listened to the audio to have picked that up. Otherwise, it may not have shown up.
I think that's what happened. I think he never listened to it. And I've seen that before, that defense don't look at videos and they end up showing them, or else he didn't think it mattered. I don't know. Or maybe he didn't listen to audio, but it was really a big mistake.
Parallel question. Did you find that and use it in the deposition of the expert, or did you wait for trial for using that piece?
We waited for trial, and they weren't going to show it, but we did. Cross-examination.
I can imagine that you probably could have heard a pin drop with the jury at that point.
Well, it was pretty amazing. They got a cart and they put a camera on it, and they got a computer to tell it how to move the cart from the top of the hill down to simulate what it looked like to her coming down the hill. And they were trying to show that she was stupid to ride down the hill. The problem is at the top of the hill, you can't see the steep part because it turns. And then there's the other turn, the sharp turn at the bottom. You cannot see it. And she hadn't gone up the hill. It's one thing that they didn't realize. She didn't come from the parking lot up the hill. She came from the bicycle curry company. There was a sideways to get up to the lower Yosemite. So she didn't know about the hill at all and couldn't see it from the top. But anyway, that's what they were trying to show, that she was stupid to even ride down. It was too dangerous. So we tried to keep it out. Not similar. There's all this shadowing. It's not the same. Judge let it in. So they're showing it in trial, and we're like biting our nails for the jury looking at this video. One of the things they did at the end was they just showed the tree. And there's like 30 seconds of the tree without realizing that that jury's sitting there thinking about that tree, and that's the last thing she saw before she crushed her neck. And sometimes engineers don't think about the effect on the jury. Anyway, after the case, we asked, and a very nice verdict, we asked the jury, what about that video? And they said, oh, all we could think about was that poor woman riding down that hill without any brakes.
Wow.
So it had the opposite effect of what they wanted to do. So it's another war story that can be used to educate people on what you do with your experts.
While we're on that case, I know that there are a lot of lawyers who have concerns about what they might describe as a rural jury. You know, Fresno being more rural than other places.
Mm-hmm.
It sounds like however you put on that case, it resonated with the jury in a way because the verdict was significant. And I understand the injuries were significant too. Were there things that you felt were done that helped a rural jury understand this?
Well, we were worried about the rural jury, and we were worried about them getting it about the breaks and all the science part of that. But you know what it ended up turning on was warning. They didn't warn. And we're talking to the jury afterwards, and one woman said, just put up a sign on the wall. Don't ride down Lower Yosemite Falls Hill. Give them a brochure that has a map, like where not to ride, where the hills are. Warn them. So all the science and everything we did, it really helped to have that simple concept of just warn people. People are entitled to it. There were some on the jury that really wanted to keep the verdict down. We were worried about people who loved Yosemite. We love Yosemite. And I think it was a good thing that we weren't suing the park. But they were willing to accept that there should have been a warning and there should have been different bicycles. These are basically they're beach bikes. You know, they're great for down in LA riding along the beach, but not for a hilly area. But that's really what it turned on.
As we talk about cases and we talk about science in terms of your background, I think one thing that I may have overlooked in terms of my questioning as far as your involvement with the lead paint cases is whether you had any sort of background with lead before you came to the law.
When I was working at the medical school at the University of Cincinnati, I was in what was called the Kettering Laboratory, working for Eula Bingham, who later became head of OSHA. But we were working on lead and toxicology, pure laboratory research with animals, exposing them to lead to try to work on what are the health effects and how to protect people and how to protect workers and consumers. And so I worked there several years in laboratory research for lead. So when I had the lead paint case, it was like everything came through full circle, that I was being able to do why I went into law, to protect people, that I thought I could do faster than in the laboratory.
Did that background factor into any of the selection process as to why the counties came to you for this?
Yes, that San Francisco County, the attorneys knew that I had this toxic background. I'm not sure they knew specifically when they first called me that I had worked on lead, but it certainly was a factor. And I used all my knowledge and information and training and education and lead during that case.
Am I correct that you probably had cases against the county before they came to you to ask you to work on the lead cases?
I had cases, premises cases or bus cases, and but they were able to put that aside. But if and there were some times during the pendency of 20 years that I had cases, but I had to ask for permission to pursue those cases against them.
And I think the reason I bring that up is I know there has been concern about civility in the law. And it sounds to me like however you comported yourself in the cases against the county before they came to you, you must have done it in a way where they were impressed with, both with your prosecution, but also in the way that you handled yourself in a way where they were totally happy working with you.
Well, I'd like to think that that is the case, that they had respect for me and how I have comported myself. And civility is really important to me. And, I belong to, as you do, American Board of Trial Advocates. And that organization is really big on civility. And I've taught their program, Civility Matters. But I'd like to think that did make a difference in the lead paint case.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts. And consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Staying with the science theme, you also worked on a benzene case yourself. Is that correct?
I've actually had numerous cases now regarding benzene, and that it causes leukemia, just like with my husband. And recently tried one in Contra Costa County that there were two brothers who both worked in a small town in Arkansas in a tire plant, and solvent with benzene in it was used to clean the rubber as they're building the tires and clean the tires, and they were spraying it in spray booths. It was they talked about the fog that was in this huge plant of benzene vapors. And both of them, after working there 30 years, one died of leukemia and one died of lymphoma. Lymphomas are also caused by benzene. So we represented the widows and grown children. You might be thinking, how did that happen that it was tried in Contra Costa County in California?
That was going to be one of my questions.
It was made by one of the defendants was Union Oil, which was bought by Chevron. And it was a battle to keep it here, but we were able to do it, to keep it in Contra Costa County where Chevron is.
How do you prove or come to know that the benzene came from a particular manufacturer?
We had information from the client's coworkers about the plant, but there had been a case that was tried before ours right there in the small little town of Arkansas, and they lost it. That was really being hometown, one of the biggest employers in this little town. But we were able to get some of the information to start off with from that case.
The defendants in Contra Costa County, it sounds like you probably fought a forum nonconvenience.
We did. The judge gave us permission to do some discovery and to prove that they did have enough nexus with California. And so now I've had 3 or 4 more benzene cases and I have one that I just wrapped up in Alameda County, and had them in Contra Costa too. So one of them that is also in Alameda County right now is one that a man was a mechanic for years and using a product made by Safety Clean, which is used to, they have a sink and they wash parts to get the oil off them, grease off of them, they wash their hands, and they contain benzene. And so the man who ran this shop and was also the mechanic got leukemia and died from it. So those kind of exposures. Also, I've had a case where a man was running or driving trucks to deliver gasoline and was exposed to benzene his whole career. So there's different kinds of exposures that, including the tire company that we tried and got over a $20 million verdict for that one. On
that side, once you demonstrate your credible threat nature to the manufacturer, a verdict like that is obviously significant. Do you find that they are more willing to resolve the case, that there's less of a causation battle, or is it a battle every single time?
It's a battle every time. And we always have a motion for summary judgment that we have to get around. Because what you have to do in toxic cases is there's 2 levels you have to prove. First of all, you have to prove that benzene causes leukemia, and then you got to prove that it causes this leukemia, which means you have to prove the exposure, that the exposure was enough to cause it. There are scientists, and most scientists do believe that there's really no safe exposure to benzene, no safe level. Of course, the defendants disagree with that. But they always say, it's not enough exposure to cause it. They pretty much have to agree that by now that benzene does cause it, but not this one. So there's a lot of hurdles. They're difficult cases. One of my first cases when I was a young lawyer was a woman who came to me and said her husband was exposed not to benzene, but to a chemical that he was spraying as a forest employee for the forestry department. He was spraying undergrowth in the forest to prevent fires. And it turned out she didn't know it until 7 years after he died, that chemical was basically Agent Orange.
Oh, wow.
And so she wanted me to sue the manufacturer for his cancer that he died of. So I did, but it turned out I had to do it in Arizona because that was where the exposure was, and Arizona had at the time a statute of limitations for injury, which was when you discovered you were injured, but not wrongful death. It was 2 years after the death, and now this was 7 years. So they did a motion for summary judgment and won because that's the law. So I had to take it up on appeal. I changed the law in Arizona. The federal court and the Ninth Circuit, and sitting in San Francisco, said you were treating two groups differently: people who are injured and people who had lost a loved one. And they changed the law. I changed the law in Arizona. And then we were able to proceed on our case, and we got it settled for.
Agent Orange, was that Monsanto?
Yes.
That must have been interesting. Have you gotten involved in any of the Roundup or the glyphosate cases?
No, I've gotten those Roundup cases, but I've referred them out.
Okay. On the benzene front, given your history, given what you went through with your husband, did you find it challenging, find it invigorating in terms of helping families who are dealing with something that is very close to the bone for you?
It is challenging. I was able, I think, because of my experience, to help them through it in a way I'd like to think that was special. And I find it really satisfying to hold the companies responsible for causing the cancers when they've known for a very long time. There were actually studies coming out of Italy, people who were using benzene, pure benzene, in the shoe manufacturing of Italian shoes, and who were dying of leukemias. And those studies go back to the late 1800s.
Wow.
But also in 1948, the American Petroleum Institute wrote a monograph that said there was no safe level of exposure to benzene. But they continued to expose people and allow it to be in their solvents and to sell the pure benzene. So it is very satisfying to me, not only because of what happened to me, but they're continuing to expose people and to hold them accountable and to get them changed and to take these products off the market, to hold them accountable and to get compensation for the people who have suffered the loss of their loved ones, or the men who are, it's usually men who have been exposed that are still alive but are dying a terrible death from leukemia, to compensate them.
I want to pivot away from some of the case work at this point. And I think where I'd like to go, again, with your permission, is to leadership. And by that, I mean roles with the Consumer Attorneys of California, roles with the American Association of Justice. And kind of from a big picture question, why have you given so much of your time to serving at the highest level president for those kinds of organizations? What's important to you in terms of giving back as far as that's concerned?
It is important for me to give back to our trial lawyer bar associations. And they've given me a lot, which is the education that they provide, but perhaps even more important, what they do to protect us from laws that are both nationally and in the state level. The people are trying to get passed to take away consumer rights. And so I'm also doing it for my clients to protect their rights and all of our practices, because if we're not practicing, we're not going to be able to help anybody. So it's been really enjoyable to be involved with the political side of things, the legislative side. I've gone to testify both in the state level and the national level, and to protect consumer rights, keep the courthouse doors open, and prevent the tort reform that will take away people's rights for holding companies and wrongdoers accountable.
Anything in particular, either from your CAOC presidency or your AAJ presidency, in terms of battles or initiatives or issues that kind of stand out as like, oh yeah, that was bad timing for me to be president, or I'm very proud that we were able to do this?
Well, when I was president of the Consumer Attorneys of California, we had the terrible 200s, which were 3 initiatives, 200, 201, and 202, which the worst one was that they were going to have 15% contingency fee. They are also going to have no-fault auto insurance, which meant that good drivers are going to pay for bad drivers. And what they were really after was the securities litigation that would really cut back on people's ability to sue security companies that their wrongdoing meant that people's life savings were destroyed and taken away from them. So that was on my watch.
That was a big year. And as I recall, given that my fees are not 15% right now, things turned out okay. We
raised $16 million. This was 1996. And we had a television campaign. We started with the no-fault insurance that good drivers would pay for. Everybody thinks they're a good driver. So, and the polling on that just crashed. Nobody liked that. And then the next one was to do the securities. And we had stories about widows and losing all their life savings. And that one crashed. Then we linked those two, because there's 200s, to the third one, which was the contingency fee. That one we won by a much narrower margin, shall we say, than the other two. But all three we were victorious on, and it was really a great battle. And it was everybody who pulled together, and we were united, and we worked hard on it. And it was just a great team of people, and our staff in Sacramento was so terrific. And we called them the Terrible 200s. It was a conference call right after they came out. The other side started their ads, and they were calling them something. I think they call them the Terrific 200s. And I said, it's not terrific. They're not terrific. They're terrible. Just like when my daughter went through the Terrible Twos. And so that was the nickname, was Terrible Twos. And it stuck. And it stuck with the people. And so we could package them together, and it worked.
Oh, I remember when you talk about people pulling together, and I think everyone does their small parts as well as bigger parts. but I remember being knee high to a grasshopper, and meaning pre-law school at Veen, being brought over to Tom Brandy's office to phone bank for this.
Oh my gosh.
So
yeah.
it was, and I bring that up because it's illustrative of how the plaintiff's bar does really coalesce, work together to help make sure that consumer rights are fought for.
I was very nervous when we knew that the other side was going to go up on the air with their TV ads, and we're really nervous about lawyers going nuts and worried about it. So I gave a speech when we were all assembled, and I said, I want to tell you about going to the grounds of the Battle of Waterloo. And we're about to have this big battle. And I went there with my brother-in-law, General Barry McCaffrey, who was at the time stationed over at NATO. And he's a real buff on military law. So he's showing us the grounds and the grassy plain. And over here, he said, was the chateau, or the Napoleon sent his nephew to find out if they still held the chateau. And then he told us about how there would be the English squares where the soldiers would stand with their bayonets in a square, and the French army would charge them on their horses. And the lieutenant would stand in the middle of the square and say, "Steady, lads." So I said, the ads are about to go up. So steady, lads and lasses.
That's a good use of an analogy. I'm going to return now to the mentoring and teaching side, and I have a personal interest in bringing this up. One of the people who graduated from being under your wing at some point is Marianne Cooper, my law partner and spouse now. It was her first job was at your firm. Yes,
she is wonderful.
So over the course of your career, you have both mentored and taught. And I know that mentoring all types, including women, have been a priority for you. And again, that's a terrible question, but I'm going to just kind of use that as a launch pad for you to talk a little bit about some of the work that you've done.
Mentoring has been very important to me, and for all young lawyers, but particularly women. And I think some of it is because it wasn't easy for me, and not just because being a woman in the law, but I started out, remember, I was single and I had a daughter and I needed a job. And so I know what it's like to have that kind of thing that you have to face, and how do you become a lawyer, and how do you manage your life along with being a trial lawyer. So it has been very important to me to work with and to teach, and I've done a lot of it around the country and here in California. And I'm glad I was able to do it for Marianne.
Well, I think of the single moms who became lawyers. There's a tenaciousness that is overwhelming in terms of what you bring to bear on a case. And I wonder if that is no coincidence. Because you're facing a highly challenging environment, it might draw people who are willing and able to rise to the occasion.
I think there's some truth to that. That when you have when you've been through a challenge and you have a challenge, that it teaches you kind of how to do it. And certainly, when you have a family that you need to support, you got to do it, and you learn to take it day by day, and to realize that it is a challenge, just day by day, rather than being sort of overwhelmed by the big picture. So, and I think that women who have to support the family, that is part of the really big challenge. Now, I have to say that at some point, I remarried, and my husband was very supportive, and that that's always great when you have somebody that helps you in that way.
As we kind of come into what I would consider to be the final strokes of our conversation, is there anything that we haven't had an opportunity to touch on that you'd like to bring forward for our audience?
I would like to say to my sisters-in-law that there are a lot of challenges. I've heard the phrase success fatigue. And when I first heard it, I knew exactly what it meant, that you have to keep proving yourself. And so what I would say to them is it is worth it, that continuing effort to show that you can do it, the underestimation sometimes, and that it's worth it because of the satisfaction that we get from helping our clients, making a difference in their lives and making a difference in society. I mean, trial lawyers, we have taken dangerous cars off the road. We've taken dangerous products and pharmaceuticals off the market. We've taken the lead paint out of houses, some of it. And so it is, it's really worthwhile, that battle that you have to face every day in the long run, and to keep at it.
I really appreciated having the opportunity to sit down and chat with you. Thank you for taking the time to share with us, Mary. Well,
it's been really great talking with you, and great questions, and I appreciate it. Thank you.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard, share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.